Did you say go ahead? I'm sorry, Mr. Chair. And I believe the witnesses in the waiting.
Oh, no.
Hold on 1 second.
Hold on, we got to wait till we go live.
We're not live yet.
It says live.
Yeah,
But I do have witnesses in the waiting room.
We are live now.
All right, thank you all very much. This is the House Judiciary Committee. It is the 22nd of February, 2021. Everybody needs to go should mute themselves if they haven't already.
Mr. Chair, we're live.
Yes, that's great. Yeah. And again, it's the 22nd of February, 2021, 1:30, and we're going to start with House Bill 766. Delegate Terrassa is going to talk for 3 minutes, and then Danielle Cruttenden and Byron McFarland, some guy from Howard County, is gonna talk. Register of Wills for Howard County is going to talk. They're going to talk for 2 minutes each, and we can let them into the room now. We'll take them all, and then we will hear questions. So with that, Delegate Terrassa, please.
Good afternoon, Chairman Clippinger and Vice Chair Atterbury and members of the Judiciary Committee. So good to be here for the second time in 2 weeks. Thank you for this opportunity to present House Bill 766, which would eliminate fees in small estates, correct a regressive probate fee schedule, and make a series of needed clarifying and technical changes to reduce the administrative burden on collecting those fees. For the record, I'm Delegate Terrassa, visiting you from snowy District 13. House Bill 766 stems from the recommendations made by the Attorney General's COVID Access to Justice Task Force. Eliminating the small state fees was one of the specific recommendations made in the final report. We believe House Bill 766 improves access to justice in the area of probate and promotes basic fairness in the fees the public is charged and enhances efficiency in the probate process. As you probably know, probate is the legal process of transferring probate assets to the decedent's heirs and those named to inherit in the last will and testament. Those are only assets titled in the sole name of the decedent. Probate assets are assets that are not jointly held. They do not have a designated beneficiary. They're not something jointly held like a house that you own with your spouse or a bank account. The existing probate fees are regressive and have not changed in any way in 30 years. The primary focus of House Bill 766 is to address the fees for small estates valued at up to $50,000. Under current law, the fees for those estates range from $2 to $150. The probate fees for these estates generate very little revenue, representing less than 1% of the revenue brought in by the 24 registers of wills collectively statewide. However, these probate fees can amount to a lot of money for families in poverty who have just lost a loved one. House Bill 766 remedies the current regressive fee schedule by eliminating small estate fees and making small adjustments to some of the other probate fees, including adjustments for inflation after decades without change. Note, small estate fees under up to $50,000 will be eliminated entirely. $50,000 to $250,000 will be reduced. $250,000 to $500,000 will see no change, and fees for estates over $500,000 will be slightly higher to offset the reduction in revenue. The chart with my written testimony lays out the changes being proposed. I urge a favorable report.
All right, thank you very much. We'll go now to Danielle Cruttenden, who is joining us. 2 minutes, please, for your testimony.
Good morning, everyone. Good afternoon, almost. Thank you, Chairman Clippinger and members of the committee. I am Danielle Cruttenden. I am on the section counsel for the Maryland State Bar Association. I'm the immediate past chair. I also did serve as the co-chair of the Life and Health Committee for the Attorney General's COVID-19 Recovery Task Force. And as Delegate Terrassa mentioned, it was a recommendation of that committee that the small estate fees, probate fee be eliminated. And, you know, I just want to point out that for those wealthier individuals in the state who are able to take advantage of, paying for a lawyer to do an estate plan or to arrange for their assets to go to a loved one at death through some type of beneficiary designation or using a revocable trust, those families have, almost immediate access to the assets of their deceased loved one. For our less wealthier residents, they have to rely upon the probate system even to just gain access to maybe their deceased loved one's final paycheck, or maybe, just the bank account or the home in which, perhaps there's not much, equity, and it would fall within the small estate description. So there is really a disparate treatment of those families that fall in the small estate category. And it is for this reason that we think there needs to be a correction and an adjustment to the fee schedule for small estates to just remove the fee for small estates altogether, and then to make a proportionate adjustment to those larger estates where there again, the smaller estates are paying a higher proportionate amount of fee as compared to the larger estates that get charged at a lower rate. So it is for those reasons that the Maryland State Bar Estate and Trust Section Council does recommend and request a favorable report. Thank you for your time.
Thank you very much. We're going to go now to Byron McFarland for 2 minutes.
Good afternoon, Mr. Chairman, Vice Chair Atterbury, members of the committee. My name is Byron McFarland, and I'm the Register of Wills for Howard County. Delegate Terrassa has eloquently summarized this legislation, but allow me to reinforce and elaborate on some of her points. This legislation makes several significant changes to our fee schedule using access to justice, basic fairness, and efficiency as our guiding principles. The elimination of the small estate fee will eliminate fees in 64%, nearly 2/3 of all probate estates in Maryland. These fees range from $2 to $150, depending on the estate's value. While this may not seem like a lot to some of us, some families struggle to pay these fees. Some are forced to pay with a credit card because they have no cash, and sometimes we actually have to set up payment plans for them. While these fees present a hardship for some of our grieving families, they also produce, as Delegate Terrassa mentioned, little benefit to the state. The fees for 2/3 of our estates account for 0.98% of our statewide revenue. This is truly nickel and diming families with the smallest estates. And from an access to justice perspective and from a public management perspective, hard to justify retaining. By eliminating these fees, we'll be easing the financial strain on Maryland families and streamlining government at the same time. Replacing our regressive fee schedule with a level playing field is similarly critical to providing a fair system for Maryland families. It simply can't be right that a $10 million estate pays a disproportionately lower fee than a $100,000 estate. This bill corrects this unjust system with one that is fundamentally fair to everyone. All told, this bill will eliminate, reduce, or keep level the fees for over 90% of our estates and benefit tens of thousands of Maryland families every year. As I stated before, the guiding principles of this bill are improving access to justice, ensuring basic fairness, and enhancing efficiency in the probate process. Simply put, everyone wins with this bill. Thank you for your time and urge a favorable report. Thank you.
All right, thank you very much. That's the testimony for the people on the bill. Anybody have any questions for anyone who has testified on the bill? The Vice Chair.
I just want to welcome my district mate with her first bill in the Judiciary Committee. And I would like to welcome our wonderful Register of Wills, Byron McFarland, to the committee. He's been here before, but not this session, so welcome. Isn't that so? They're amazing. That was
Those were insightful and detailed questions. Are there questions for the panel? They were worthwhile questions. Seeing none. Thank you all very much. That concludes the testimony for House Bill 766. See how this works, committee? We're only 13 minutes into this. Delegate Malone is next for House Bill 1250. He has himself and Byron McFarland is back, so we should try and keep him, and Angela Valerio. Angela Valerio is going to be testifying. We won't give her a hard time. All right. Let's see, Delegate Malone, are you ready for your 3 minutes? Where are you?
I'm here. Do you hear me?
I do. There we go. Whenever you're ready.
Yes, this bill originated, and thank you, Mr. Chairman, my fellow committee members, but this bill originated from a bill that I brought about 3 or 4 years ago to increase the spousal share when someone dies without a will, they die intestate. And at the time, if a spouse um, had passed away, the surviving spouse, if there was no children, would receive 15,000 and half of the estate. And then it would go back up sort of the tree and would go to parents. That has since been modified, and now the amount has been increased. And in fact, if folks have been married, I believe it's now 5 years, the spouse receives all of the estate. But this was just one example of a lot of part of our intestate laws that sort of have not kept up with the times. And Professor Valerio will probably provide a couple more examples. And the thought is to send this to a work group to bring us into the modern age, and to also possibly bring us into to consider some of the uniform laws that apply in the rest of the nations, to bring them here to Maryland. That is the gist of the bill, and I will now defer to Professor Valerio and Mr. McFarland if he's going to be testifying in this bill.
Professor Valerio, you have 2 minutes.
Thank you. As you know, I am Professor Valerio, and I teach at the University of Baltimore School of Law, where I have been teaching for over 20 years. Trust and estates is my area of expertise. Intestate succession laws don't get a lot of attention because they are the laws that protect the unrepresented. And as Delegate Malone stated several years ago, starting in 2017 and ultimately in 2019, there was a small tweak to the spousal share in a situation where the decedent and the spouse were childless. And essentially, the spouse had to share the estate with the decedent's parents. There are other areas of our intestate succession laws that are also very outdated. For example, if the decedent and the spouse had only shared children, oftentimes you will find that maybe even minor children will end up owning a half of a principal residence, which creates lots of complexities. Also, Maryland is one of the only jurisdictions that looks as far as descendants of great-grandparents. Some of those people aren't even known to the decedent before allowing property to pass to stepchildren, a non-blood taker under the laws of intestacy. So although people should have wills, many don't. And the framework of intestacy that Maryland has is very outdated. And along with the change that was made in 2019 with respect to the spousal share, the entire framework needs to be examined. And that is exactly what this task force would do. Thank you.
Thank you, Professor. If we could go now to Byron McFarland.
Thank you again, Mr. Chairman. Again, my name is Byron McFarland. I'm the Register of Wills for Howard County. It's great to see Professor Valerio, who's a friend and mentor for the first time in a while. I'm not going to speak too long. I'm just going to echo what Delegate Malone and Professor Valerio have said. Our intestate laws have not changed in almost 50 years. And as Professor Valerio said, we've had a couple of little tweaks over time, but really, in 50 years, I think what we kind of culturally think of as a family has changed. And Delegate Malone pointed out, I think, one of the glaring provisions that should be looked at, which is really contrary to what I think the average citizen thinks. People think if I die and I have a spouse, they inherit everything. And that's not the case under Maryland law. And I think that the last thing that we want people to deal with, and this is what I deal with every day, is when someone has lost a loved one, throwing some sort of curveball at them based on antiquated law that really upends their life. And that's not right. And as Professor Valerio said too, we are one of the only states we look to as distant as a second cousin 5 times removed to inherit from us if we don't have a will before a stepchild, before someone we've been partnered with for 50 years and but for a marriage license are essentially married. And I think that with those, those are questions that I think a task force would be able to address. And the last thing I'll just say is I would just encourage one amendment to this, which is that under the bill, there are no registers of wills included in the task force. And we're usually the ones on the front line trying to help people figure out exactly who the heirs are and who they need to contact. So I would just encourage respectfully that that one of us might be able to help with shaping or informing whatever recommendations the task force might have. So with that, thank you again for your time and attention.
Thank you very much. Yeah, I did notice that there's a missing from the Register of Wills. I did notice that there would be one representative of the University of Baltimore School of Law, though. Anyway, are there, with no disrespect to Professor Valerio in any way, shape, or form, are there, some people don't like to serve on task forces. Are there any questions for the panel? Seeing none, that concludes the testimony for House Bill 1250. It is very good to see you, Professor Valerio. Good to see you as well. Register of Wills McFarland. We're going to move on and we're going to go to House Bill 870 now. 870 with Delegate Hill, who will get 3 minutes. Karen Pope Onwoke will testify, followed by Morris Klein and Ron Lansman. All of them will get 2 minutes. Just to be clear, Ms. Pope Onwoke, I apologize, is speaking in favor. Mr. Klein, Mr. Lansman are favorable with amendments, but we'll hear everybody all at once. So, and then we'll take questions. So Delegate Hill for 3 minutes, please.
Thank you, Mr. Chairman, and thank you, Vice Chairman and committee members. So I'm Terry Hill, and I'm presenting House Bill 870, which is a bill that, like many other bills that you've been hearing, arose out of the Attorney General's COVID-19 Access to Justice Task Force, which, as you probably know by now, was designed to develop strategies and solutions to address the significant civil legal challenges facing marriages in the wake of the COVID-19. So I served on the Life and Health Planning Subcommittee, and this is one of several recommendations that we came up with dealing with people during COVID-19, which is to change the Maryland General and Limited Power of Attorney Act so that the short form and the long form would allow for a principal to assign an agent the authority to help them apply for Medicaid and other government benefits.
To change the Maryland General and Limited
Mr. Lansman, if you would please go on mute, please.
and the lawful.
Thank you.
Thank you. We've worked with the elder law and the estates and trust sections of the Maryland Bar to try and ensure that in allowing this additional authority, a principal would still be protected from abuse or misuse of their funds or being taken advantage of, frankly. And as you can imagine, particularly in the times that we're living right now, when you have someone who is in a nursing home or in a hospital situation, but particularly a nursing home situation, whether they're disabled or elderly, now that we have restrictions on who can visit and what they can do, it makes it even harder for them to be able to manage many of their affairs. In order to apply for Medicaid, often you have to distribute different wealth or things that you own, or assign it differently. And there are forms you have to get, medical forms, banking information, all kinds of forms that people may not be able to do. And so we think with the amendments that are noted on page 6 and 23, that we can safely allow for, again, people who feel they need that kind of assistance to assign someone the authority to do the things that they're willing to do. And I think if you look at my written testimony, it goes into it in a little bit more detail, but that the witnesses will also add something to it. So essentially, it will allow the agent to access the financial, medical, and other supporting documents required in applying for Medicaid on behalf of the principal. It will allow them, most importantly, to hire a Medicaid planner and pay for a Medicaid planner out of the principal's funds, which actually helps them to spin down to be eligible for Medicaid and to avoid the potentially expensive and lengthy process of pursuing guardianship in order for the principal to assign someone, usually a loved one, to help them to get the benefits that they're entitled to receive. And with that, I will remain for questions. Thank you very much.
Thank you very much. We'll go now to, and I do apologize for mispronouncing your name repeatedly, so let me try and mispronounce it again. Apologize again. Is Karen Pope Onwukwe.
Well, I have to congratulate you because you pronounced it correctly. Well,
all right, committee, that's the one time I got it right. It's time for me to, I'll see y'all later. I'm done. All right. You have 2 minutes. We're happy to hear from you.
All right. My name is Karen Popanukwe, and I have submitted written testimony. I'm an elder law disability rights attorney, and I practice in Prince George's County. I have been practicing since, in my own firm since 2000. I do plan, help people plan for Medicaid long-term care. And the main reason that I wanted to testify in reference to this particular act is that at the time we first did the uniform durable power of attorney, I was chair of the Elder Law and Disability Rights section of the Maryland State Bar. And we were supportive of the bill. But what we found in the aftermath is that, and I guess I know you all understand that you can sometimes pass legislation and the practical application of the law can make you understand that there are some changes that need to be made. One of the practical applications that happens, and I'll give you the most common examples I have are someone who's a family who their loved one has been involved in some kind of medical malpractice and there's a settlement, or someone who has been in a major car accident and there's a settlement. Even if that family comes to me and they have, when their loved one had signed a power of attorney, a general durable power of attorney, it doesn't provide the necessary authority for them to do planning. So what the family, after they've gone through this trauma, is very traumatic. Even if you have a settlement, because normally those things take years to work out, once the person's family comes to my office, they're waiting to receive a settlement check, but they cannot receive it because they have to go through a guardianship process. And under our laws, it is very cumbersome, and it's another stressful activity that the family has to undergo in order to, all they want to do is structure the family's life so that they can take care of the person who who's now disabled.
Onwukwe, I'm sorry, if you would please wrap up. We've got to.
I would ask you to support this because we need to be able to make it so that families that have been traumatized by some kind of a catastrophic event will be able to get help for their family members in a much easier fashion. Thank you.
Thank you very, very much. Morris Klein now is favorable with amendments, and we'll hear from him for 2 minutes, please. And committee, I'm sorry, let me stop right there really quickly. Committee, I have to step away for another quick meeting. The vice chair will be taking over from here for a little bit. All right, so Mr. Klein for 2 minutes.
Yes, thank you. Thank you, Mr. Chair. Thank you, members of the committee for this opportunity to speak in favor of this legislation with amendments that has been submitted as part of the written testimony. I am the past chair of the Elder and Disability Law section, actually the immediate past chair, and also was on the Life Caring Task Force that Ms. Cruttenden mentioned in testifying for a previous bill. A significant part of many of our members' practices involves drafting powers of attorney. Indeed, it, along with a will and a healthcare advance directive, are the three essential documents of estate planning that all people should have. 11 years ago, the General Assembly, through this very committee, enacted a power of attorney law that was intended to make it easier for individuals to sign powers of attorney. The legislature developed some standardized forms that became part of the legislation, which has been adjusted from time to time, most recently last year. This bill allows individuals to establish special needs trusts and make other financial transactions to protect their spouses and other family members from becoming impoverished, or to set aside funds for disabled family members in a special needs trust. I have to say that anybody who I write a power of attorney for, I would include the information that this amendment tries to now include in the power of attorney law. I have offered, or our section has offered, additional amendments and further clarifications to separate transfers that would be of limited value from transfers that would be of unlimited value, which they would have to initial on their own. We also remove a double negative in one provision to make it a little easier to understand. We hope that you will give this bill as amended a favorable report. Thank you.
Thank you. And now Mr. Landsman.
Thank you. I appreciate the opportunity to discuss this today. So my prepared remarks cover what I have to say. So let me just illustrate it quickly. It's a common experience for elder law attorneys to have a client come in. The example I'll give is a woman who comes in whose husband has Alzheimer's disease. And we want to get him qualified for Medicaid, and we want to protect her, and maybe there's a disabled child or another relative involved. Oh, she says, don't worry. My next door neighbor is a communications lawyer, but he helped me get a power of attorney, so we're all set. And then I look at the power of attorney, and it's the statutory form. And the problem is the communications lawyer doesn't know what's not in it. That's always the trick. And so it doesn't have anything about public benefits. It doesn't have anything about gifting. And so it's of no use. And now that the husband no longer has capacity, we have to now get a guardianship if we're going to do anything effective for this family. So that's the problem we're trying to solve, is to have the statutory form is a great idea. It covers a lot of situations, but it lulls people into the false belief that they've done all the planning that they have to do. And so a little extra provision that puts a little notice to people who read it, who know a little bit about this, will say, oh, there's public benefits here. We better think about this and address it. I'm reminded of an experience I had some years ago when I was trying to understand a contract someone sent me outside of my area of expertise. And I read it over and I said, it's going to take me all week to figure out what's in here. And then I thought, oh, it's going to take me about a month or a lifetime to figure out what's not in here. So that's the problem, is that those of us who know this area know what to put in, but people who don't know it don't know what's not there. And this amendment is well designed to deal with that problem. I'd be happy to answer any questions that you might have.
Thank you. Are there any questions? I see Delegate Williams.
Thank you, Madam Vice Chair. And I just want to, just thank Delegate Hill for bringing forth this bill. I appreciate it. I think it's very needed. I appreciate Mr. Landsman's example that he gave as someone whose dad has Alzheimer's. We dealt with a very similar issue in trying to get his VA benefits for him. I wanted to just kind of follow up with the comments from Ms. Karen Poponique, who I'm happy to see today as a friend and a constituent. I was wondering, Ms. Popanikwe, if you wanted to elaborate a little bit more. I know you were cut off with time. A little bit more of the example that you were trying to give as to why this bill is so necessary.
Well, thank you so much, my delegate that I'm so proud of to have be my voice in Annapolis. But one of the things that I wanted to, well, I'm going to just read this. This is in my testimony. On once the governor created his the executive order that allowed us to be able to do this remote witnessing and things of that nature. They set out guidelines for us to help our clients. However, if you are trying your best under the pandemic, a lot of people came to us because they had had a loved one go into the hospital. They could not even talk with them. It makes it very difficult for them to plan. And this is what we're talking about here, is that people have to be able to plan when your life is completely turned upside down. And I think everyone now understands that how that happens. How are they going to be able to make it so that they can get medical assistance, long-term care? And a lot of these people are not, it's not that they're very wealthy people, but in order to qualify for medical assistance, long-term care, you have to have limited income. So I'm hopeful that you will understand that this is not just for wealthy people, this is for people who don't have the means and they need assistance from the state to take care of their loved one who's disabled. Thank you so much.
Thank you. Delegate Bartlett, did you still have a question?
Well, I wanted to say hi to Ms. Popanikwe, but and I was going to ask for an example so that I would have a question, but Delegate Williams beat me to it. Although I will say hi. Isn't that so?
Well, I am so pleased. I have to say this. I'm so pleased at this Judiciary Committee. I believe it looks like our country. I'm so proud of Maryland everywhere I go. And I look at you and I'm very, very, very proud of Maryland. We're such a progressive state. And this is reflected in the Judiciary Committee. I'm just really pleased and proud of all of you. I can't go through everyone that I know here. Delegate Davis and Delegate Hill.
Thank you. Delegate Cox, do you have a question?
Thank you, Madam Vice Chair, and thank you to the panelists. Real quick, I think it's a great opportunity for improvement. This form and the purposes that you've mentioned, I've absolutely agree with updating it. My specific question is on page 26. Just a clarifying question, line 17 to 20 talks about the agent power of attorney having power to gift the principal's assets. So I'm wondering, is that in addition to the current powers of attorney authority, and how would that differ from a trustee, for instance?
If I may, so a power of attorney has to be effective for gifting, a power of attorney needs to explicitly mention that authority. So a power of attorney that just says you can do whatever I can do is not a terribly effective power of attorney. And this committee recognized that 11 years ago when it enacted this law. So there does need to be something specific in there related to that particular subject. Again, we tried in the amendments to sort of separate limited gifting, which would be defined in this document as the twice the federal estate tax gift exclusion, or $30,000 per year per person, to unlimited gifting, where the individual will have to specifically initial that provision rather than just say it's okay without specifically initialing that. So that's how we've tried to approach that.
And if I may, would that then trigger the fiduciary responsibilities as a trustee, similar to a trustee in that situation, or how does that
Well,
work in the?
an agent under a power of attorney is a fiduciary and has the obligations of a fiduciary to act in the best interest of the principal, just as a trustee has a fiduciary obligation to act in the best interest of the beneficiary of the trust.
And how would that differentiate between a challenge to a trustee's actions? I'm just curious as to how this would play out in case of a family member. And I practice this area as well. And so, sometimes a family member will, it seems easier to me in my trust practice for a family member to challenge a power of attorney rather than a trust that has greater powers potentially. Do you see any concern with that or how that might play out?
Well, trusts seem to be more favored by financial institutions and more accepted by them than powers of attorney. Sometimes it's a struggle to get a power of attorney to be accepted. And indeed, the legislation originally 11 years ago put teeth into the statutory power of attorney to require third parties to accept powers of attorney or face paying for the legal expenses to get it to be accepted. So the statute does have some oomph to it to have third parties accept them.
If I could also answer, I mean, partly the statutory form is really intended for people who are somewhat unlikely to retain a lawyer to do this planning. So people who have trust have substantial assets and are getting presumably expert advice. And the very problem with the statutory form, for all of its virtues, is that it prompts people to think they don't need a lawyer to get advice. And this is meant to alert them that there's more that they have to think about.
And in the trust, one of the beauties of the trust is the indemnification, so that if a family member were to sue, a lot of times they're divested under the trust. Do you have that same protections for a power of attorney here, or is that something that we should consider looking at?
I don't know if we'd want to do that.
Yeah, I guess once you have a family fight, you've already lost, of course. But yeah, I don't think I would do more than authorize it and let the competent agent persuade people that they're doing the right thing with the right advice.
Thanks so much.
I would add one more thing to that. Normally, I get a lot of people that come to me because they've gone to a credit union or a bank and they've had a pushback on using their power of attorney. And normally when I contact them and tell them that, and I give them the language of the statute saying, if they don't accept it and it conforms to the statutory power of attorney, then they're liable. Then, and so it is as Morris and Ron alluded to, people who don't have attorneys, a lot of time, they're the ones that are getting the runaround and getting treated badly. So this is something, because attorneys like us that do this, we know what to put in our power of attorney, but it's regular people that are trying to get things done.
I support it. Thanks so much, everyone.
Thank you. Thank you, Delegate Hill. And that concludes testimony on House Bill 870.
Madam Chair,
Now,
may I ask a question?
Yeah.
Since I don't have access, do you have amendments? If not, I will make sure that we get them to you in your bill file. Do you have any amendments?
I don't have any, but they might be in the main office.
We'll double check to make sure you have all the amendments that have been offered.
Oh, yeah, I see. Council says we have them. So,
all right. Thank you very much.
Thank you. Okay, moving on to House Bill 1264, Delegate Juanita Fisher, and there are two witnesses. And so we're bringing them in.
Thank you, Madam Chair. Can you hear me okay?
Uh-huh.
Okay. My Google was picking up your voice and it said, I don't have a response. It was funny. Can I start, Madam Chair?
Oh. Yeah, I see they're coming in here. So
Okay.
go ahead.
Okay. Good afternoon, House Judiciary Committee. for my 3 series of bills this afternoon. I'm going to keep my testimony very, very short and leave it up to the experts. These bills have resulted through our different bar associations and issues surrounding doing legal work during COVID and digital times, and I will leave it to the experts and be brief. For HB 1264, it's an estates and trusts bill to change the administrative, the payment and commission of attorney's fees, and I will just leave it to my panel to go to the bill. Thank you very much.
I will call Michaela Muff. Oh, your whole name wasn't on my sheet. I'm sorry.
That's okay. I saw that online.
Okay.
And just to confirm, I missed it coming in. This is House Bill 1264, correct?
Yes.
Yeah. Okay, great. Thank you, Madam Vice Chair, members of the committee. My name is Michaela Muffaletto. I'm the chair-elect of the MSBA Estate and Trust Law Section. We're requesting a favorable report on House Bill 1264. This bill is a one-word change in Section 7604 of the Estates and Trust article from may to shall, as relates to the payment of fees and commissions without court approval when all interested persons have consented and the amount being requested is below the statutory cap. Under Sections 7601 and 7602 of the Estates and Trust article, personal representatives and attorneys are entitled to reasonable compensation for services rendered. To secure that compensation, they're required to file a petition with reasonable detail, oftentimes attaching invoices, and that petition is subject to review and approval by the Orphans Court. There's no doubt under those 2 sections that fees and commissions are within the discretion of the Orphans Court and subject to their approval. The same cannot be said, however, of Section 7604. It was enacted in 1997 as an alternative to the petition process for the specific stated purpose of authorizing the payment of fees and commissions without court approval when the total compensation sought is under the statutory cap and all unpaid creditors and interested persons have consented. The intent of Section 7604 was to reduce judicial oversight, thereby reducing the overall cost and simplifying the administration process. The opposition put forth by the judges suggests that a review of fees and commissions is always within their discretion. We respectfully disagree with that. There are circumstances in a modified administration, for example, when everything is done before the Register of Wills, nothing, including a consent to compensation, ever goes before a judge for their review and approval. We believe the same applies to fees and commissions under Section 7604. If the Orphans Court can review fees and commissions even when they're below the statutory cap and when all interested persons consent, then in fact no fees and commissions can be paid without court approval. This is contrary to the intent and the plain meaning of the statutory language in Section 7604. The words "without court approval" can only have one meaning. Judicial oversight of fees and commissions under this section is not in the best.
Can I ask you to wrap up your testimony? Yep.
It's not in the best interests of Marylanders. It's going to cost more money, take more time. It doesn't foster judicial economy. And I think it will restrict access to some by attorneys who are unwilling to get involved when courts can sua sponte usurp the consent of the interested persons who are paying those fees. For these reasons, I believe that the one-word change from may to shall in Section 7604 is necessary, and we request a favorable report from the committee.
Thank you. Howard County Register of Wills, Byron McFarland.
Good afternoon again, Madam Vice Chair. My name is Byron McFarland. I'm the Register of Wills for Howard County, and I want to express my strong support for this bill. I support it as a Register of Wills, working with grieving families every day, as an attorney who understands how seriously members of our profession take our duty to charge fair fees to our clients, and as a citizen who believes that our government should not stand in the way of members of a family who have managed to find consensus. As Mrs. Muffaletto indicated, this legislation is necessary because some orphans courts interpret current law as permitting them to cut or deny attorney's fees in these limited instances. We don't believe they do, and this bill will make it crystal clear that these courts cannot substitute their own personal preferences for the judgment of the parties whose own inheritance is at stake. This bill will ensure that the wishes of the interested parties are respected. Opponents of this bill have argued that judicial oversight is needed to protect, in their words, uninformed members of the public who apparently can't be trusted to know what they're signing. Second guessing a citizen's competence to consent to pay attorney's fees is both invasive and inconsistent with scrutiny over other types of consents in probate. There are numerous times in probate when interested parties offer their consent to the initial appointment of the personal representative, to the waiving of bonds for those personal representatives, and to the probate of copies of wills. The courts never questioned the competence of individuals signing those consents, so these should be no different. When courts interfere with unanimous agreement among family members in an estate, it prolongs probate, delays resolution to a loved one's death, and injects uncertainty into an otherwise harmonious process. We should respect the judgment of our citizens, encourage harmony among family members, and afford them a swift conclusion to their loved ones' estates. I urge a favorable report. Thank you.
Thank you. And questions? I see Delegate Cardin has a question.
Thank you very much for coming in, and thank you for testifying on this bill. Ms. Muffaletto, are there instances you can give us examples where judges refuse to grant the amounts that have been requested unanimously?
So personally, I have never experienced it, although after testifying today, I'm sure if it doesn't pass, I will experience it. I have heard from colleagues of mine who have been involved in estates where they are, well below the cap, and they have consents from everybody involved who are, quite frankly, the ones who are paying the bill, where they file the consents with their account, and the judge is, sua sponte, in their review of the administration account, decide to make inquiry about the fees or commissions that are being requested on the consent. And I've heard that they've been denied because they're not, being held until the end of the estate. So I know it's happening. It hasn't happened to me personally. I do believe that it's time for a fix to make sure that this doesn't continue to happen.
Are there any other questions from the committee? Seeing none, thank you. That concludes the testimony on House Bill 1264. Moving on to House Bill, 1264. Now moving on to House Bill 1266. Delegate Fisher, and one of your witnesses is already here, and we're bringing in Ms. Hubbard.
Thank you. Thank you, Madam Chair. Should I begin? Is that okay?
Yep, here she comes. Go ahead.
Okay, thank you. Again, committee, back with my series of bills. This is HB 1266, Estates and Trusts, Wills and Custodianship. This bill alters provisions governing the custodianship and deposit of wills by establishing duties and requirements applicable to the custodian of wills, allowing a person having custody of a will other than the testator, the person that made the will, testator's agent, to deposit the will for safekeeping with a register of wills, and to authorize an attorney to dispose of a will in a specific matter under certain conditions. These series of bills, I also forgot to mention in my previous, are cross-filed with Senator West and worked on behalf of the association. So I will let my panel continue with testimony. Thank you, Madam Chair.
Okay, and Ms. Muffaletto, go ahead, you have 2 minutes.
Great. Thank you, Madam Vice Chair. Members of the committee, again, my name is Michaela Muffaletto. I'm the chair, or the vice chair, sorry, of the MSBA Estate and Trust Law Section. We're requesting a favorable report on House Bill 1266. This bill revises Subtitle 2, Article 4 of the Estates and Trusts article relating to the disposition of original wills, which in its current state is extremely limited and outdated. The statutory changes found in House Bill 1266 fill many gaps in the existing law. Currently, there are no provisions with respect to the disposition of an original will by any person other than the testator, that's the person who's making the will, or the testator's agent, while the testator is alive. House Bill 1266 expands the class of persons who can dispose of the testator's will to any person who's in custody of that will. Because people frequently lose their wills and may no longer maintain safe deposit boxes at their local banks, oftentimes custody is given to the attorney who prepared the will. The current law doesn't provide any alternatives for us for disposing of a will that's old, or when no one knows where the testator is, or even if the testator is still alive. For attorneys who safeguard wills and decide to retire or even pass away, a further problem is created, and attorneys and their successors tend to come up with their own creative solutions not permitted by the law, and which, quite frankly, might not adequately safeguard the testator's last wishes. We believe House Bill 1266 provides solutions for all of these issues. It will authorize any person in possession of a will to deliver that will to the Register of Wills for the county where the testator resides, or where the testator resided when the will was executed. It'll also give authority to the testator's guardian or an agent acting under a power of attorney to demand a testator's will from a person who has custody of that will. We believe House Bill 1266 fills many gaps in the existing law and will provide a greater access to justice for Marylanders by helping to ensure that original wills are safeguarded properly, and will eliminate the guesswork that goes into trying to locate these wills. For these reasons, we request a favorable report from the committee. Thank you.
Thank you. Christine Hubbard, you'll have 2 minutes.
Good afternoon. My name is Christine Hubbard, and I am testifying on behalf of the Maryland State Bar Association, the Estates and Trust Law section, in favor of House Bill 1266. This is really a housekeeping bill. There's a hole in the law, and it will really allow those who are looking to dispose of an original will clear guidelines on how to proceed. And it really makes it easier for people who are looking for wills to find them. As Michaela said, under current law, if someone is holding an original will and they cannot find the testator, they can't give it to the testator because they can't find them, and they can't record it with the registrar's office. They're stuck with it. So they have to come up with their own solutions. So if they're an attorney with a couple hundred wills in their possession, and they're retiring or moving out of state, many times these wills wind up in the back of a retired attorney's garage, perhaps in a safe, but forgotten about. So these poor families who can't find a loved one's will are forced to go through a costly and inefficient intestate proceeding. Worst of all, the last wishes of the testator cannot be honored. So the solution is very easy to fill this hole in the law. It simply allows for the holder of a will to record that will with the Register of Wills where that person resides or where they resided when they signed it. So it also provides a sensible method for destroying very old wills that are highly unlikely to be probated so long as an electronic copy is maintained. So in sum, House Bill 1266 is a housekeeping bill, provides greater access to justice, and prevents wills from being lost so those testators' last wishes can be honored. We ask for a favorable vote on House Bill 1266. Thank you.
Thank you. I see 2 questions, Delegate Cox and then Delegate Cardin.
Thank you, Madam Vice Chair and members of the panel, and Delegate Fisher. I get the focus of this bill, I think, is a great one because you're trying to prevent wills that should be considered as part of probate from being destroyed. I think that's an excellent focus. The concern I had was in reading through it, it says that an attorney could not destroy a will, even if it's been replaced by a new will by the testator. Is that an amendment that needs to be considered or that you're offering, or am I misreading?
I think I'll take that one, Christine. So there's only one valid last will and testament, and that is the one that is the most recent. If you look at the first paragraph of almost every will, it revokes all prior wills. And so the only will that these changes speak to are the final valid last will and testament.
If I could follow up real quick, my concern with that is, as you know, and I do a lot of probate sometimes, there's a dueling will, and different members of the family might have a different copy, and the whole dispute is whether or not which one is the valid will. And sometimes in the course of the proceedings, the real issue is that the attorney or the party failed to destroy the old will when the new will was made. And this appears to require it to be, at least from my reading, the attorney would not have the authority, even with the authorization of the testator, to destroy that. Now, maybe I'm overreading it, but it just seems like it's a potential issue. Is that?
I don't think this statute changes the existing law. Again, once a will is revoked, it can be destroyed. I think it probably varies from practice to practice. I know in my firm, we keep every piece of paper that we ever produce. So if we have 10 wills that are old and one current will, we have copies and originals of all of them. We don't ever destroy them. And so I don't think this changes that. I don't know if Christine wants to add.
Yeah, the law already directly addresses this in that there is the revocation of a will is specifically addressed, and the testator can absolutely destroy their own will, or they can direct the destruction of their will. And a will is also considered destroyed if it is superseded by a new will or a new amendment to a will. So that is actually already addressed in a different section of the law.
But if I may, real quick, and I apologize, but when I read this, it says that you can't do that if the testator's it has passed. In other words, there is, just as Ms. Muffalato mentioned, sometimes I know in my practice, if the testator wants it destroyed, I destroy it immediately. I follow whatever the will is of the testator, but as Ms. Muffalato mentioned, sometimes they don't say, and so sometimes you have a safekeeping, and then after the testator dies, all of a sudden you have an old will and a new will, and the whole question becomes whether or not the new will was duly authorized. This seems to create a problem in that even if the evidence is there with the attorney that the old will was meant to be destroyed, that after the testator dies, at least, they can't do that. They have to send it to the Register of Wills and wait 10 years and then up to maybe even 25 years.
So there's a requirement when somebody passes away that if you're in possession of their will, you have to deliver it to the Register of Wills. So again, I don't think this changes that, but there is only one valid will, and this would only apply to that one valid will, not to any wills that have been superseded.
Right. And if there are two wills and you can't figure out which one is valid, let's say there's one will that's 10 years, that was signed 10 years before a more current will, and there's some question about whether the current will is valid, and it's a real question, I think that may have to go to court for resolution. Both likely need to be filed with the appropriate register, but the personal representatives in the family have the ability to go to court to resolve that.
So just to be clear, if a testator passes and in their newly executed will, they made it clear that the other one was revoked, then your position is under this, the attorney would not have to send both copies to the register for a future destruction. The one that's revoked, the attorney would have the authority still to destroy that.
I'm not sure I'm 100% understanding your question, but I'm going to attempt to answer it.
Well, let me clarify then real quick. So you just mentioned, Ms. Muffalato, that you have maybe 5 wills because you keep the past copies. If the testator dies, I just want to be clear that you don't have to send, that we as attorneys don't have to send the past revoked copies. We can destroy all of those.
Correct. Thank you for clarifying that.
Okay,
that is correct. You only would have to send the one true valid last will and testament.
Okay, thank you.
Delegate Cardin?
Thank you very much. Well, I don't see the Register of Wills on here to talk about this, but are we creating an issue where everybody is going to start storing their wills with the Register of Wills? And then we're going to have to figure out once they want to have a new will that is generated, then they're gonna have to figure out how to get that will over, and the Register of Wills is gonna have to figure out which one to destroy. And I'm all about this. I'm just making sure that we're not opening up a can of worms.
So I appreciate that question, Delegate Cardin. I wish Byron, Register McFarland were still on here, because he is, if I could speak for him, and I've spoken to him many times about this bill, he is in favor of this bill, even though it has the potential to result in, attorneys like myself doing what I would call a will dump. If I decide to retire, and I take my 1,000 wills that I'm safeguarding at my firm and decide to dump them to the various registers office around the state, we have been assured by every register that we've spoken to that they would be more than happy with that result. Again, as Christine said, it creates clarity and certainty, of where to look for these wills. On the listserv, we see on a regular basis, hey, does anybody have a will for, Jane Doe? If there was one direction, or if everybody knew based on what the law was, that the likely place would be the registrar's office, then I think a lot of people would start their search there rather on the listserv.
And one quick follow-up, would we create a situation like, if I have a will and I'm, I want to make sure that everybody knows where my will is, I'll send it to Baltimore County, Baltimore City, and Carroll County, because I have, and maybe, I happen to have a condo in Aspen, Colorado. God willing, someday I'll have a condo in Aspen, Colorado, and I send it to the Register of Wills in Aspen as well. I mean, am I going to have an issue there that I'm going to have all these wills out there?
Well, hopefully you're only going to sign one true original will, first and foremost. But again, we've spoken with the registers, most of them here in Maryland, and they have within themselves a statewide database, so that if somebody is looking for a will, they can type it into the system and they can see, okay, this will is not in PG County, it's in Carroll County now. And so I think it will be a lot more streamlined, and I think they're ready for these changes. These statutes haven't been amended for 4 or 5 decades, so it's time.
Okay, thank you very much, Delegate Cox. You had an ample opportunity, my friend. We're going to wrap this up, okay? Thank you very much for coming, and that concludes the testimony on House Bill 1266. Moving along to House Bill 1261, Delegate Fisher, and 2 of your witnesses are here. We're just bringing one back in, so you can go ahead and begin.
Thank you so much, Madam Chair. Don't you guys love my trifecta this afternoon? I know the committee's enjoying it. This is Delegate Fisher, and I'm presenting HB 1261, Wills, Powers of Attorney, and Advanced Directives, electronic execution. As you know, the last year and change has been a new landscape for practicing attorneys here in Maryland. This bill would change the method in which wills, power of attorney, and advanced directives may be executed, allowing wills and POAs to be executed electronically, witnessed remotely, allowing written and electronic advanced directives to be witnessed remotely, and providing requirements for protection of electronic signing and remote witnessing, and establishing that wills, POAs, and advanced directives would be conformance with executive orders during their time in effect. This bill, I think, is very timely and appropriate, especially over the last year where so many people have lost members of their family due to COVID, and attorneys helping these families have had to deal with a lot of struggles and not having the ability to do certain things electronically. I will leave again, and I want to thank my expert panel for working on this legislation, and I will leave it to them, to their testimony and questions. Thank you very much, Madam Chair. And I believe that's it for me this afternoon.
Thank you. Okay, next. I'm going to pronounce your last name wrong, but you're my soror, so I'm going to call you Soror Karen and let you introduce yourself, and you can go first.
All right, well, thank you so much. My name is Karen Pope Onwukwe, and I think you have my written testimony, it gives you my bio. But I think the most important thing I want to emphasize for this testimony is that I was on the Life and Health Planning Committee of the Maryland Attorney General's COVID-19 task force. And part of the studies that we did, we were looking at what kinds of things we could encourage the Maryland General Assembly to do to make it so that the citizens of Maryland will have easier access to legal services. One of the things that we identified, and I'll give you an example, when the COVID first happened, I was devastated because I had clients who had wills, drafts of power of attorneys, drafts of trust documents, and I didn't have any way to get them executed because I couldn't meet with them. I left my office on March the 12th. I still have not gone back to my office. I really thought, I didn't know if I would even be able to practice anymore. But thank goodness that the Maryland State Bar Association worked with the governor's office, and we got an executive order. I had to completely change my life. I now meet my clients remotely. My mother, who's 86 years old, is one of my witnesses, and my son is my other witness. We meet with I meet with 90-year-old people, and we sign documents. This is such an important piece of legislation, just so that we can continue to offer services to people. You know, we talk about the new normal. This is the new normal. And to exclude people from being able to sign their documents, you can't imagine how anxious people are nowadays to get their wills done, to get their power of attorneys done. And they need an avenue that they can do it and not feel concerned about their health. At this point, I'm hopeful that you will vote favorably for House Bill 1261 so that we can allow the citizens of Maryland to be able to continue to remotely get their documents signed.
Thank you. Thank you. Michaela Muffletto for 2 minutes.
Great. Thank you, Madam Vice Chair and members of the committee. Again, my name is Michaela Muffletto. I'm the chair-elect of the MSBA Estate and Trust Law Section. We're requesting a favorable report on House Bill 1261. This bill, obviously, it came about as a result of the COVID-19 pandemic and the need for us to serve all Marylanders in a time of crisis. To help understand the need for this bill, a review of its evolution, although you've heard some of it is necessary. I think to start, though, we have to rewind the clock to where we were a year ago. Like Karen said, a year ago, I was in my office in downtown Baltimore. At that time, none of my fellow estate planning attorneys or I could foresee the effect the COVID-19 pandemic would have on our practices and the lives of our clients. Estate planning at that time was done predominantly in person. To be executed properly, wills, powers of attorneys, advance directives, they all required the signer and the witnesses to be in the physical presence of each other when the documents were signed. But last March, however, with the growing concerns over the spread of COVID-19, the implementation of social distancing requirements, I and my colleagues were in quite the conundrum because the pandemic highlighted the need for many people to get their affairs in order, but the law prevented us from helping them without risking our health and the health of our clients. At that time, our section worked diligently with the governor's office to secure the order that authorized remote witnessing and electronic execution of these documents. They put into place specific safeguards so that the execution had to be supervised and certified by a Maryland attorney to guard against risks of fraud and undue influence. This order changed how we could meet with clients, sign documents, and quite frankly, broadened the people that we could reach. As part of the COVID-19 Access to Justice Task Force, they made recommendations, one of which was to make permanent the governor's order that allows for remote witnessing and electronic execution. And that's exactly what House Bill 1261 does. While some have expressed concerns over this bill because of the risk of fraud and undue influence, we believe that the certification safeguards that are included in House Bill 1261 will alleviate that risk. Passing this bill will allow us to continue to serve Marylanders even on the other side of this health crisis. It will allow us to serve those who are particularly hard to reach, oftentimes the most vulnerable, and will create an access to justice where there wasn't one before. For these reasons, we request a favorable report from the committee on House Bill 1261.
Thank you. I see a question from Delegate Williams, who has never seen Frozen.
Oh no, I've seen Frozen. It's actually one of my favorite movies that I watched with my goddaughter. But my question has nothing to do with that. And actually, Ms. Muffaletto, you started to actually kind of go into what my question was with, I did see the comments. I don't know if you saw the letter from the Maryland Catholic charities. Anyway, the Catholic Archdiocese expressing concern about, you know, this bill may open people up to fraud and coercion and abuse. You know, how are people able to verify that they are who they say that they are, as well as, you know, that there's no one else in the room with them, there's no one forcing them to execute these documents that they're reaching out to you all about. And so you started mentioning that, but that was my question. I didn't know if any of the practitioners here want to kind of elaborate about those safeguards that are in this bill to prevent those things.
Well, I will say that a part of the executive order, we're required to record the execution of the documents. And we're also asked to verify, and I have the people take their driver's license, hold it up to the screen. And I just do that for everyone, even the people that I actually know, because I want it to be routine, so that we have a documentation of what's going on. But I will say this about that. I have had fraud with power of attorneys, even when they were done the old way, back in if someone has larceny in their heart, having them sign a document remotely is not going to change what people are going to do. I think that this gives us more of a safeguard to have it recorded. That's I don't have any data to back that up, but that's my opinion.
Delegate Cox? Delegate Cox, do you have a question?
Real quick, Madam Chair, thanks so much to everyone. I wanted to know if the sponsor or the panelists would be amenable to a small change striking out or other electronic means on the definition of electronic presence to require a visual in order to do this. And then I guess in the context of that, along with the Catholic Conference's concerns, to make sure there's no one else, a certification that there's no undue influence, anyone else in the room or anything like that, that would be inappropriate.
So I just would like to add to one part that Karen just said. This law adds tools to our toolbox on how we can meet with clients and sign documents. It doesn't change the old way, funny to say the old way, the in-person way of signing these documents, but by adding the certifications, what that helps us do is guard against the additional risk that might be posed by doing these signings virtually. Attorney certifications, there are specific items relating to these documents that we as attorneys have to certify. More times than not, these are clients that we've known for many years, or that we've met and we've been working with them on their estate planning needs. It is not that we're meeting with them to sign these documents for the very first time. By the time we meet with them to actually sign these documents, we know who they are. We know who their children are, whether they're married, whether they have kids and grandkids, what their assets are, how much value is in their bank account. I mean, we know a lot of intimate details about these people that are signing these documents. So I think we've addressed or guarded against, better said, the risks that might be inherent in a remote execution.
Thank you.
Just on my question, just on my question, though, Madam Chair, I didn't hear an answer to the question. I think it's great audiovisual, but you're adding in or other electronic means. I think it probably would be appropriate. I think it'd be a good compromise to strike that. What is your position on striking telephonic without the visual? In other words, requiring visual.
Yeah, thanks, Delegate Cox, for that. I'd be happy to discuss it when it goes to subcommittee.
Okay, are there any other questions?
That's great. I just didn't know what the parties were, but okay.
Seeing no further questions, that concludes the testimony on that bill. Thank you for being here. Thank you, Delegate Fisher, for your trifecta. And that concludes the hearings for the Judiciary Committee for the day. Enjoy the rest of your day, folks, because tomorrow, not so much.
Thank you. Thank you.